Well, thank you very much for joining me on this video. I want to talk to you today about a piece of legislation that was introduced last year known as the Homeowner Protection Act of 2024. It really covers a number of things. It deals with the Ontario Heritage Act. It introduces something called the Personal Property Security Act. It touches on the Planning Act. But there's two specific aspects that I want to deal with here. The first one is the introduction of a cooling off period. As you know, for years now, under the new Condominium Act, there's been provision for buyers to change their mind when they're buying a new condominium. We call it a cooling off period. Of course, when you're buying a new condominium, often it's a concept you're buying. It's like buying timeshare. You really don't get in and see it. They're starting to build. They're selling you on pictures and plans and so on. Generally speaking, it can happen when you're buying a new home, but often you walk in and see the home and the finished product. But there's specific things that they want to deal with here in terms of giving you the opportunity after you've made a firm commitment to buy the house to back out. And there's three things that you need to keep in mind as far as a time deadline. The first is that the date, the prescribed information that the builder has to provide has been given to you if you happen to be the purchaser. Secondly, the builder has to do certain things, and after he's done those things, the time period starts, or after you receive a copy of the agreement of purchase and sale. So there's those three things. He has to give you certain information, he has to perform certain specific acts, and you have to get a copy of the agreement of purchase and sale. Only after all three of those things are done does the 10-day period start. And this 10-day period gives you the right to rescind the agreement of purchase and sale, no questions asked. In other words, you don't have to give a reason why you're backing out. Your reason is, change my mind. And of course, if you got somebody who's a first-time buyer, they're skittish a little bit, they're kind of watching the calendar and realizing that the days are ticking on to this 10-day period. On day 11, they've bought the property. So it may be right up to the 11th hour or the 10th day before they pull the plug, but they can. Once they decide to pull the plug, the builder has the obligation to give them back all their money, and the builder also has to give them interest on their money. So that's the first thing we need to talk about, and that's that cooling off period for new construction. Bear that in mind when you're representing a builder selling a new home. The second thing is the liens registered on title, and it comes under the Personal Property Security Act. And it's really primarily targeted at who they feel are the elderly and vulnerable. Remember, there was a commercial on television some years ago that said, well, he had a clipboard, and the wife was explaining to the husband, or the husband explained to the wife why they signed a contract that bound them to usually a hot water system, could have been a furnace and air conditioning system, and they were locked in for 15 years. What would happen is somebody come to the door and they say, how much are you paying? Can I have a look at how much you're paying for your hot water tank rental? They'd look, they say, well, we can beat that. When we can come in and we'll save you $2 or $3 or $4, whatever, sign here. And they were committed now, but they were committed for the 15-year period. And if after 3 or 4 years they sold the property, the new person didn't want the hot water tank, they had to pay out the entire amount of payment that they would pay for the whole 15 years. And so the government said that that's taking advantage of the vulnerable and the elderly. One of my salespeople came in to see me last week, and he was dealing with an elderly client. And when he met her, when he went to see her, she already had $40,000 in additional liens on her home. But the interesting thing, going down into her basement, she had 4 water softeners in her basement. And people would come knock on the door, and she thought they were coming to inspect her water softener. They had her sign the papers. What they were doing was selling her a new water softener over time, leasing another, and unscrupulously, because they would go downstairs and they would see it was already one there. They'd hook a second one in tandem. Next piece would come along, hook up a third one in tandem, and so on. And they knew what they were doing, but the consumer didn't, and the consumer was being tied into all these things. They also said this is often the case where they're selling them a loan to get renovation done on their property, but they're locking them into things that isn't in their best interest. And this law that we're mentioning, the Notice of Security Interest Act, has some teeth with it. They're saying to the lawyers, they're putting them on notice that they better be acting in the best interest of their clients. and they are liable to get prosecuted if they don't. It says failure to meet a licensee, that's a lawyer or paralegal's obligations when acting for either the lender or the borrower in relation to the notice can result in regulatory measures being taken against them. In other words, some kind of a sanctions can be taken against them. It's very, very concerning. And so they brought in this act, and the impact of the act is rather interesting. It says that any existing liens on property is deemed to have expired if those liens were put in place prior to the introduction of the Homeowner Protection Act 2024. And they can be removed from title. So what that means is that if you have, if you're looking at buying a home and on title there is a hot water tank because there's a 15-year lien on it, or there's a furnace, or there's an air conditioning unit, whatever the case might be, it can be deemed to have expired, and your lawyer can say, no problem, we will just petition to have it removed from title. Another one of my agents came in, said that exact thing happened to him, bought a property, didn't want to assume the hot water tank, it was on title. The lawyer said, no problem, we will just remove it from title. Now, some of you are probably aware that recently, most of our hot water systems that are rented came under Enbridge, and even though it wasn't tied in with a specific contract, it was still tied in for a 14-year period. And so after 3 or 4 years, if you wanted out, you had to pay all the payments accelerated that you would have paid for the remaining 10 or 11 years. And now Enbridge and Endercare have separate billing. So if you're a landlord and you are renting out a property and the tenant agrees to pay the gas, for example, up until now his bill included the hot water tank rental. Now it doesn't. Now there's a separate bill that comes out. It's going to go to the landlord. The landlord's going to sit down with the tenant and sort it out. All these things, when you are a realtor and you're representing your seller, you have to come in and contemplate it. Because if you're selling a property, the buyer is not bound because he can remove those things from title. So when you go to take a listing, you want to find out what the story is if the hot water tank is rented. Even if it's Enbridge and they've never signed a separate contract, there's no guarantee there isn't something on title. If you're representing the buyer, that's if you're representing the seller, I'm sorry, if you're representing the buyer, unless the buyer assumes that contract, he's not bound by that contract. And so his lawyer can remove any lien on title and he can just put in his own hot water tank if he wants. Now, I haven't got a definitive answer on what kind of security the companies have that put the equipment in. Can they come in and remove it? How can they go after the seller? It's going to be the seller that they're going to deal with. But you as a realtor have to be on top of this. Whether you're representing the seller or representing the buyer, you want to ask the questions, find out if there's specific things that are being leased, and make sure that they understand the security isn't in place on title like it used to be. I hope that makes sense. Thank you very much for investing your time. Talk to you again next week.